Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I am right here on this station at this time every Sunday morning from 8 to 9 a.m. to bring you, the landowner, the information that you need regarding natural gas development here in Pennsylvania. And just in case anyone wants to know, or maybe does know or knew at some point but has forgotten, I have not, do not, and I will not represent gas or pipeline companies. You hear me say every once in a while, look, I grew up as a steelworker farmer kid in Armstrong County. I started early on. I spent my early part of my career as a public defender, and I continue, and my plan is to continue to represent individuals, to represent people, to try to even the playing field when sometimes the deck may be stacked against you. And certainly when you're dealing with multi-billion-dollar market cap energy companies, the deck may be a bit stacked against you. So we need to make sure we're getting you information, education, and high quality representation to even that playing field. Because this, though everything may seem, hey, we're all friends, we're a partnership, well, as many people know, as you go forward, that partnership, once you sign an agreement, seems to disintegrate. And then, and I say this a lot, that agreement, whether it be a gas lease, pipeline, any other type of agreement, that agreement is the blueprint, the basis of how things will go forward. The verbal, the oral, the statements that are made to you by the landman who is seeking to get your signature on that agreement. Those statements are not part of your contract. So when that contract is interpreted as it goes forward by that company, or maybe that contract is assigned or transferred or sold to another company, by the way, either in whole or in part, meaning a piece of it could be, well, they're going to look at that contract. They're not going to say, oh, what did Joe Smith, the landman, say to you? No, they're going to look at that contract. So if they said, yeah, we're going to put in one pipeline, and then all of a sudden they put in one pipeline, then all of a sudden they come back and they put in a second one 5 years later, and a third one 5 years later, and a fourth one 5 years later, and a fifth one 25 years later. When you say, well, wait a second, Joe, the landman said we're only going to have one pipeline. Well, sir, your agreement allows for unlimited pipelines to be installed at any time. Your agreement lasts forever. So that is what your agreement says. That's what you have agreed to. And if you wanted to only have one pipeline and you wanted to limit to only one pipeline, well, you should have did that before. You should have did that when you were negotiating and before you signed the contract. They are not going to go back and say, well, let's find out where old Joe, the landman, is and see what he said to you guys. No, they're going to look at the contract. We need to make sure as the landowner side that we are negotiating initially from the beginning the best possible contract or agreement that we can negotiate. And that means to increase money, to make the payment schedule more beneficial for you as the landowner, the royalty owner. And it also means to strengthen the addendum or added terms to the agreement. And addendums are critical. Addendum are key. But you have to know what you're doing. I'm not going to talk too much about royalty today, but I will say, if you follow the show, I talk a lot about royalties because it is a multi-million, and actually, in all seriousness, it is a multi-billion issue. So we're going to talk about it. But today I'm not going to focus on royalty, but I am going to say that as a royalty addendum, if you're a regular listener, you'll hear me talk about royalty addendum all the time. And wow, there are a lot of different ways that you can write royalty addendum terms. And they can have completely opposite meanings and everywhere in between. And that is the same type of principle with almost all of the other addendum terms. Now, the royalty terms are the most complicated, most convoluted, built-in loopholes that are very beneficial to the company. But same thing when you look at pipeline agreements, well pad agreements, meter site agreements, pipeline, all of these agreements, you have to be careful. And you should be getting assistance for somebody working for you, not the landman who's working for the company. We all know better than that. We all know, we all have common sense. We all know we're not going to rely on somebody working for the other side whose goal and motivation is to get the best possible deal for them. Why would we rely on their agent working for them to educate us, to tell us what we should do? Well, we shouldn't, because the landman works for the company, not you, the land owner. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. You can call us anytime, 570-307-0702. Just want to briefly state, Susquehanna County, these Cabot multi-unit well consent documents, not as simple as they look. If you get a multi-unit well consent, you should be getting assistance. You should be getting an evaluation. I do reviews and consultations of these multi-unit well consent documents, usually take an hour or two. Encourage you, if you have a multi-unit well consent request from Cabot, encourage you to consider calling us, or call us, 570-307-0702. Learn about reviews and consultations and see if we can help you. Again, whether you call us, 570-307-0702, or call someone else, call someone who knows what they're doing, who is working for you, not the company. Okay, before I get into the heart of today's show, I just want to tell a little story. And sometimes these things come up and they serve as outstanding reminders that I need to talk about this on the radio show. And had that experience in the last week. That experience was involving a landowner, mineral right, oil and gas right owner who was considering selling all or a portion of his oil and gas rights to one of those companies that sends you information in the mail. You know it if you're in oil and gas area, you know it. You get these letters quite often, and my first advice to people is generally put the letter down. But again, the show's never specific advice, and for some people it may make sense to consider or sell their oil and gas rights. Generally, not specifically, but generally, I'm not a big fan of doing that, because usually my experience has been that the landowner has regretted that decision of selling the gas rights. But again, this is not specific advice. So what do I say to people? Well, generally, again, I say, hey, look, give us a call. If you are seriously considering selling all or any of your oil and gas rights, give us a call, set up a review and consultation. What we do is you send us the offer, your information where the property is located, the lease document, and any other documentation you may have. I look at that, familiarize myself, study it before the call or in-office meeting. Then we have a discussion. We review the pros, the cons of selling your oil and gas rights. We look at what information is available in your area regarding past production and potential future production. So this gentleman who I spoke with was considering selling his oil and gas rights. So what happens sometimes is that people get very frustrated because they were promised by their friendly landman back several years ago when they signed their lease that they were going to be rich. Very, very rich. Maybe even showed them royalty calculators to show just how rich they were going to be. Now we fast forward several years, whether it be 5 years, 8 years, 10 years, 4 years, whatever number we want to pick. And that individual who was promised not fortune, not fame, but riches, well, that's not happened. So that person has become very frustrated. And sometimes that person has a lot of acreage. And what also can happen is the person may be signed and didn't get a really great deal in their gas lease because maybe they signed a little early. And now here they are. They didn't get a big bonus. They have a bunch of acres. They're not receiving royalties, or they're only receiving very little royalties. They get a letter in the mail offering to sell gas rights $4,000, $5,000, $6,000, $7,000, $8,000 even per acre. And they say, well, you know what? This seems like this is an opportunity I should take. So what we do then? What do we do in this situation? Well, again, we look at the specifics of your situation. And I cannot say it enough how important specifics are in everything related to oil and gas development. I don't care what your neighbor did. I don't care what the guy who works for the state did. I don't care what somebody else with the lawyer did. I care about what you are going to do because it's in the best interest of you, not your neighbor, not the guy at the state, and not the other guy with the lawyer. No, we want what's right for you, and that's what we do. We need to get specific. And as development occurs, knowledge and information about development, production, pipeline capacity, pipeline infrastructure becomes more and more important. We need to look at drilling activity, drilling schedules, multi-well drilling on a single pad. How is your company developing? All of these things and many more come into play when you're going to make such an important decision. So we look at those things. And in some cases, we're able to communicate directly with the gas company regarding their drilling schedule, their drilling plans, which are, of course, subject to change, but valuable information. What we want to do is collect as much relevant information that we can so we can evaluate that information to guide this extremely important decision. So sometimes we're able to get really strong information regarding future drilling plans. Sometimes we're not. Every situation is different. In this one example, generically, we were able to determine that right around the corner, there is substantial development plans for this property. And when I say right around the corner, I mean right around the corner. And we have a very strong idea how many wells are going to be drilled, the approximate length of the laterals, what type of unitization this property is going to see. Imagine if you owned 200 acres and only 10 of your acres were unitized, then you're very frustrated. You get an offer to sell the gas rights. You say, hey, this sounds pretty good. But then you find out, wait a second. Hypothetically, in 3 months from now, there's going to be multiple wells drilled. All of my property is going to be unitized, and it's all going to be developed. Now, I may be, and probably will be, incredibly glad that I reviewed this information and got this information before I made a permanent decision to sell my oil and gas rights. Permanent decision. If you are considering selling your oil and gas rights, and think about it, $3,000, $4,000, $5,000, $6,000, $7,000, $8,000 an acre. If you're not doing a review, consultation, evaluation before you sign anything, before you sign anything. I can only say I don't know what you're thinking, because it's such an incredible decision. It's a permanent decision to divest yourself of potentially your greatest potential future asset. And you're not going to invest an hour or two of time to have a review and consultation. This gentleman, in my opinion, probably saved himself probably millions of dollars. And I think we talked for combined with the review and everything for less than 2 hours. And I'm not saying that this happens all the time. I'm saying that it happens. And you better be prepared for that, and you better be taking care of your specific situation. And look, hey, maybe you don't like yourself. Maybe you don't care. But think about your family and think about future generations. Most people want to do the best they can for themselves. A good lawyer is going to do everything they can to help you make the right decision so you do the best for yourself. A good lawyer got nothing involved in this except to give you the best possible advice to allow you to make the right decision. So if you're considering selling your oil and gas rights, do not sign anything before you consult with a knowledgeable attorney, before you look at this in every possible way. Why I say before, I have people at times will call the office after they signed a sales agreement. Guys, that's too late. Call before you sign anything, any document. Don't sign and then call. Hey, I want to have you take a look at this. Call first. Let's look at it, and then you decide whether you sign. I say this to people. I don't tell people sign or don't sign. I will give you the information and education the best that I can to allow you to make that right decision for yourself. Now, sometimes I will say, look, this is really clear. I think you should sign this. This is a great deal in this market. This makes a lot of sense. Sometimes I may say, look, this is terrible. It's up to you, but there's all these different problems. I don't believe that I would sign it. I'm probably more inclined to tell people or to recommend people sign things than to recommend they don't, because we don't know what the future is. But boy, there are a lot of bad agreements. And I talk to people, and I know after we review them, they don't sign them. And they did that because they made an educated, informed decision as to what was best for them. That's what we want to do. We want to do reviews, consultations. We want to make sure that you're making the right decision. We do these reviews and consultations on leases, selling and buying oil and gas rights. We do them on every type of document, any type of agreement, on anything, on legal issues, royalty issues, if unitization issues, bad faith issues, any type of issue, to start off that process and then see, okay, do we go further or do we have the information that you need now? I want to give you the most effective representation I can, and we found that works very, very well for people who own property all across Pennsylvania, regardless of your location. So you can always give us a call, 570-307-0702. Again, I'm attorney Doug Clark. You can call the Clark Law Firm, find out if we can help you. Maybe a review and consultation, maybe straight representation, maybe royalty issues. Who knows? But give us a call, 570-307-0702. We've helped a lot of people. Go check out pagasleaseattorney.com. Check out pipelineattorney.com. Check out the testimonials from prior clients. We are very proud of those. So we'd love to hear from you, and we'd love to help you. 570-307-0702. And a reminder for Susquehanna County and some Bradford County residents, this Cabot multi-unit well requests. Everyone's getting them. Let's take a step back, in my opinion, not specific advice, but you need to understand this. You are, in my opinion, modifying the terms of your lease permanently. I do not like the idea of simply signing these documents. This is not specific advice. My specific advice, would be give us a call for review and consultation or call someone, but you have to understand that these are powerful documents. And just because the company says this is what we're planning, absolutely, positively does not mean that is what's going to occur. So I think you need to limit these documents. That, yes, I'll agree to what you're proposing, but I'm not going to agree to this document to allow these types of wells, any type of well in the future of any kind. And maybe you don't even drill off the pad you're telling me. Maybe you come back. Again, I'm not saying this happens. I haven't seen it yet. But maybe I sign a multi-unit well consent document, and then you come back and you put a pad on my property and use my property to drill 25 wells. There's nothing that I'm aware of that would stop that. So now that's an extreme example, but it's a possible example. There are many others that aren't so extreme that you need to learn about, you need to understand, and you need to make the right decision. So you can always do reviews, consultations, 570-307-0702 with me, Attorney Doug Clark of the Clark Law Firm. Make sure you're joining us every Sunday from 8 to 9 a.m. right here in this station. I'll be right back after this super important message. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you join us every Sunday from 8 to 9 a.m. right here on this station, where I bring you, the Pennsylvania landowner, the Pennsylvania royalty owner, the information that you need. Not what the company wants you to hear, but what you need regarding natural gas development here in Pennsylvania. And I want to go back for a second, because at the beginning of the show, I jumped into some things. I just want to remind everybody, again, obviously I only do landowner, royalty owner representation, but for items, again, gas leases, gas lease reviews, amendments, gas lease modifications, pipeline agreements, water line agreements, meter site agreements, releases, Tioga County well pad releases. If you're signing a release, you may be giving up claims that you may have now or in the future. Releases are very important documents. Be careful signing releases if you do not have an attorney. They are very complicated, filled with legalese, designed and evolved over time to protect the party presenting you with the release. Be careful. Well pad releases. Please be careful. Get assistance. I also do royalty deduction, royalty issues, unitization issues. Again, any and all matter related to oil and gas development. Any and all matters. So you're looking for information, two things to do. Give us a call, 570-307-0702. Go to the websites, pagasleaseattorney.com, pipelineattorney.com. Ask yourself this question. If you have a computer and if you're presented with a pipeline right-of-way agreement, why would you not go to pipelineattorney.com and learn, get information, become more informed and educated? Go take advantage of the websites, whether you even ever call us. I'd love to hear from you. But if you don't call, take advantage of pagasleaseattorney.com. Take advantage of pipelineattorney.com. The information is there. Take advantage of it. I have been doing this radio show, All Things Marcellus, since August of 2010. August of 2010. There are hours and hours of radio shows available on the websites. Get a pen, write it down. pagasleaseattorney.com. pipelineattorney.com. Check out the websites and get informed. You can always Google Attorney Douglas Clark. Find my websites. Check it out. And make sure you Google Attorney Douglas Clark. And if you Google, you'll understand why. Okay, let's get back into it. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. So, all right, what I want to talk about now is we got landowners. You've heard me talk about this before, this idea of something called a top lease, which is when you have a current lease and a company wants to present you with a new lease. You already have a lease, and the company wants to present you with a new lease. Normally, again, basic concepts here. Normally, a top lease historically was presented by another company, meaning that if you were leased to company A and your lease was set to expire, say, within a year or so, general terms, nothing magical about a year, but say your lease was going to expire in about a year, and company A was not going to develop your area. That it's a known secret that you're not going to be developed in the next year by company A. Well, company B knows this known secret, and so what do? They say, hey, company A is not going to develop you, but company A still has a year's worth of time on their lease, so we would like to come up and lock you into a new lease, even though you have a year left on your existing lease. That is your classic top lease. So it may make sense to do that. If you're presented with a top lease, turn on the broken record, give us a call somebody. But there are special considerations and concerns with any agreement, but certainly with the top lease. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. So the top lease, what we're looking at is we want to know, when are you going to get paid? How are you going to get paid? We want to negotiate the best possible terms, of course. So that situation arises. Another quick little side note. There is an item in these top leases, or in your original lease and most leases, there's a provision or a term in many leases that say that if you receive an offer from another company during the term of your lease, meaning a top lease, but if you receive another offer during the term of your lease from another company, and sometimes it'll say even for 6 months after, or maybe even a year after, that you have to go back to company A, my example, and say, hey, company B offered me this lease, and you have to present the lease offer to company A and give them the chance to match it. That's called a right of first refusal. That can be problematic. So just watch out for that. And sometimes we'll negotiate and eliminate rights of first refusal in the original document. But if you're considering a top lease, you need to be careful, because you need to make sure that you're complying with all the terms of your original lease. I am attorney Doug Clark, and this is All Things Marcellus, and make sure you join me every Sunday, 8 to 9 a.m. right here in this station for the information that you need as a Pennsylvania landowner. So resetting then, we have a top lease situation where you have a current lease that's active. You haven't received royalties. There's no drilling. And a second company, not the company that holds your current lease, but another company approaches you and says, hey, we'd like to do a new lease. Again, your first thing is, well, how are you going to do a new lease? I have a current lease that doesn't expire for the next year or two. And that company says, no, we're pretty comfortable that lease is going to expire, so we'd like to enter into a new lease. Again, I don't want to go too far down this path, but boy, a question you should be asking is, well, if I sign this lease today and my old lease doesn't expire for a year or two, well, in a year or two, is that when I'm going to get paid for this new lease? If for some reason, if you as a company do not accept the new lease, or if the other company actually ends up developing under my existing lease, then what happens? Do I get any money? Well, if you're going to be doing a top lease, you certainly want to be negotiating for money now and not in a year or two when your old lease expires. You also want to make sure that you're protecting yourself from any liability with the existing company. So again, there's a lot of things that you need to do. Landmen want to get signatures. They don't and cannot offer you legal advice in how to protect yourself. So we need to make sure you're protecting yourself in that situation. I am attorney Doug Clark, and this is All Things Marcellus. So That's a top lease situation. But as my friends in Tioga County know, there's another extremely common situation that's occurring in Tioga County where the landowners have leases that are expiring next year, maybe the year after, but they're expiring in the future, and those leases are held by SWEPI LP, which is owned by Shell, I believe. And so these landowners who have leases that are expiring 2018, maybe even 2019, maybe the end of 2017, but a lot of times the 18, 19 are being offered brand new leases, not by a new and different company, but by SWEPI LP, by the same company that holds their current lease. Why is that happening? Well, we'll talk about that after this very important break. You're listening to Attorney Doug Clark of the Clark Law Firm. Real quick reminder, Susquehanna County residents, multi-unit well consents from Cabot. Get assistance. We're doing reviews and consultations. See if we can help you. 570-307-0702. Get assistance. These documents, in my opinion, are far more powerful than they may first appear. I'm not telling you not to sign. I'm telling you to get assistance. We do those reviews and consultations, usually take an hour or two, see if we can help you with that or any other matter. 570-307-0702. 570-307-0702. Get assistance. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. We're going to jump right into it here. Reminder, you can always call us 570-307-0702. I represent Pennsylvania landowners, oil and gas right owners, royalty owners, all across Pennsylvania. Love to hear from you. Love to try to help you. See if we're right for you. 570-307-0702. Okay, so we talked about a top lease, and that's the scenario, generally speaking, when you have an existing lease that's set to expire sometime in the future, say a year or two. We'll just get some examples here. Generally speaking, people consider top leases when you're leased to one company and a new company comes in and says, hey, we think your lease that you have with this other company is going to expire, so we'd like to do a new lease with you. There are special, unique, important considerations and concerns that you must address in this scenario. Excellent opportunity for review, consultation, understand what your rights are, and get the groundwork, the framework to how that process works. Decide, do I want to even engage in this process? And if I do, now I have the information to engage in this process more effectively. So that's number one. Now we have another scenario, which you can also look at as a top lease, but I'm submitting that most people think of top leases when a new company comes in to offer you a lease when you already have an existing lease. Another scenario, which is very common today, it's occurred in other places as well, but very, very, very common today in Tioga County area, and specifically with the company SWEPI LP, where they have current leases, where landowners are under lease now with SWEPI. SWEPI then goes and approaches that same landowner. Send a landman out, go and approach them and say, yes, your lease expires in 2018, 2019. We want to come offer you a new lease. Well, again, that's the same company that holds your current lease. Same company offering you a new lease. Well, certainly that company knows whether they intend to develop your property under your existing lease, or if they're not going to develop it, that lease is going to expire, and then they need a new lease to develop your property. So they're coming to you now when you have a year or two left on an existing lease with the same company. Now, this didn't just start. This has been occurring for a while now. Certainly a lot of it last year. I've done a lot of reviews and consultations for Tioga area residents who are in this exact scenario. They have a lease, but with Sweppy, who owns the lease, and now here comes Sweppy offering a new lease. Boy, flags should be going up. Why is this occurring? I need to figure this out. One thing that I encourage every person to do, if you're in that scenario, is to ask the landman who works for the company, not you, the landowner, to ask them, why is Sweppy offering me a new lease when they currently hold an existing lease that doesn't expire for another year or two? Now, what gets really interesting is the offer on a per acre bonus level is typically, we're seeing get these calls all the time, $1,000 to $2,000 per acre in bonus. We see these offers out there all the time. So if you as a company own a lease and it doesn't expire for a year or two, why are you going to go out and offer a landowner $1,000 or $2,000 an acre? And imagine, let's pretend a person has 100 acres. Well, if you're offering them $1,000 an acre, that's $100,000 as a bonus. If you're offering them $2,000 an acre, well, that's $200,000 bonus. Well, that's a lot of money. That's a lot of money. It's a big carrot that is in front of the landowner as a motivator for that landowner to sign the new lease agreement. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So why are they going to give you $1,000 or $2,000 per acre or somewhere in between? Well, let's look at your original lease and let's look at your new lease. Well, if your original lease was at 15% royalty and the new lease is at 12.5% royalty, well, that may be a reason. And again, we're talking generically. This is not specific advice for anyone, but that may be a reason that the company says, hey, we'd rather give the person who has 100 acres, let's pretend it's $2,000 an acre. We'd rather give them $200,000 and have a new lease agreement. And that new lease agreement is 12.5% royalty instead of 15% royalty. Or maybe your original lease has royalty addendum language that would stop, preclude, or minimize the amount of deductions that the company can take from your royalty payments. So there, again, hypothetical. Maybe your original lease was for 15%. Maybe your new lease offer is for 15% and $2,000 an acre. So why is that occurring? Again, maybe. These are all things to be thinking about. We're asking the questions. Why? Well, maybe because your old lease doesn't allow for deductions or minimizes them, and the new lease allows for complete and total deductions. So maybe the company would rather you have a lease that allows for deductions, and they would be willing to pay maybe $200,000 to a 100-acre landowner in order to have a lease that allows for full deductions. Again, maybe. These are scenarios. Maybe, let's go another scenario. Maybe the old lease is 15%. Maybe the new lease is 15% royalty as well. But maybe the old lease allows for no deductions or minimizes deductions. And the new lease not only will allow deductions from royalty payments, but maybe the new lease will allow for the company to sell your gas to its affiliated company and then pay you royalty based on the local index price. Most people are probably going to be scratching their heads. You listen all the time. You hear me talk about this. To me, that's an important thing. To me, it's an important thing, and it gets complicated. But what you can take from it is is that, again, maybe it's worth paying someone $2,000 an acre in order to switch the royalty calculation method. Maybe it's worth it. Maybe you have a 100-acre landowner who's offered $2,000 an acre for a lease. Their existing lease doesn't expire for another year or two. So $2,000 an acre for 100-acre property. That's $200,000 bonus payment. Maybe it's worth it. Maybe it's worth it for a company to give you $200,000 so they can change the royalty calculation method that will exist during the lifetime of that lease for the next who knows how many years, 50 plus years, who knows. Maybe that's worth it. Maybe that's what they're doing. Let's circle back. When that landman comes to your table and says, yeah, you have an existing lease, it expires next year or the year after, but we want to give you this new lease, we want to give you 1,000, 1,500, 2,000, whatever that number is, we want to give you that. Well, the question is, why? Why? And see what kind of answer you get. See the type of answer. And we need to ask this question. I believe that in many, many cases, that the reason is the royalty calculation method. Those are things that we talk about in great detail during reviews and consultations. But we have to look at your scenario. Your scenario. There may be other reasons, but we need to look at these, and then we need to weigh your options and saying, well, geez, maybe if I do this, I can get this bonus, which I find very attractive. But maybe if I do a new lease, I will be now subject to the new lease, which has a far worse royalty calculation method built into it than my original lease. And what I mean by royalty calculation method is, how are you going to be paid royalties? How is your price of gas going to be determined? From a local index, from a sale to an affiliated company? Or is it going to be determined by what your gas is actually sold at in the open market? We need to look at that. You need to understand that. And we all have those detailed conversations. But look, if you're sitting there and you're looking at $200,000, and that's life-changing money, that's a lot of money. And you say, well, yeah, I understand I may suffer from future royalties, but boy, I think this is the right move for me. Well, then maybe that makes sense. Those issues and many more are what we talk about in these reviews and consultations. And then you have the tools. Then you have the information. Then you have the education to make the right decision. Do you sign a new lease? Do you wait? Do you negotiate? How do you go forward? You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can always contact us, 570-307-0702. I personally do all the reviews and consultations. It's me and you and I, family and I. We will get to the bottom of it and get you the information you need. 570-307-0702. One more segment. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So let's summarize here in the last segment a few things. We talked in the first segment about selling oil and gas rights and why you should have a review, consultation, seek some legal advice before making that decision, and most importantly, before signing any document. Then we talked about top leases being offered in areas from other companies who do not hold your current lease, which is due to expire in the near future, let's say a year or two, and a different company wants to offer you a lease. That's like a kind of a classic top lease example. Then we also have, which would still be a top lease, but the example where there's a company who holds your current lease, but they're simultaneously coming out and asking you for a new lease. And we see that a lot in Tioga County with a company called Sweppy LP, which I believe is owned by Shell. So what does that mean? Well, again, we talked about potential reasons why that may occur. Now, it may also occur, hey, look, the company just can't get to it in time and they need to buy some more time to develop your property. But what's interesting, and what my experiences have been, and again, I represent landowners and oil and gas right owners. That's what we do. And my experience is if a company says, hey, we want to drill this, we're not going to be able to get to it and your lease expires next year, one common way to address that may be an extension, a lease modification to give the company some more time. But why in Tioga are you not offered an extension or modification of an existing lease that still has another year or two on the lease? You're not offered that extension. No, you're offered a brand new, entirely new, different lease. Look at the royalty language. Think about it. Why are they not offering me a new lease? Here's a common example. Your lease may expire because you were fortunate enough to have the foresight, maybe even the luck, to have a limitation on how long the gas company could what's called shut in a well that's on your property. Or not on your property, but it's part of your unit or holding your lease. Let me clean that up. So you may have a case where the company drills a vertical well down to the Marcellus formation, caps it, and never produces gas from it. And now it's been 6 or 7 years that well has been capped. If that's the case too, by the way, I'd like to hear from you. But if that occurs, or you're in year 4 of this capping, and the company knows they're not going to turn that well on and start to run it in the next year, and so you have maybe a 5-year limitation on how long that well can be shut in. So the company, your lease is going to expire then, let's say 2018, because the company is not going to produce gas, and in 2018 they will have reached the maximum allowable time to have a well of yours shut in. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. So the company knows the only thing we have that's holding this person's lease is this well, which is vertical down to the Marcellus, and we have it capped, and we don't plan on producing from this well ever. We're not going to be able to develop by the time 5 years of shutting comes in. So let's go out and do what with that landowner who has a shut-in provision, which means that his lease will end if they don't produce gas next year. Common sense may tell you that the company would want to buy themselves a little more time. Maybe they can produce gas in 2 or 3 years, but just not in the next year. So what do they want to do? And I've dealt with this many times. They want to extend the shut-in. Hey, can we add another year or two to the shut-in and maybe we'll offer you some money? They don't, in my experience, come and offer you a totally new lease. Not when there's just one thing they need to address. Well then, why are you being presented with a new lease? There's probably another reason. That gets back to the last segment. Why are all the different reasons? And you need to be asking the landman, well, okay, why, if the only reason why my lease is going to expire next year is because of the shut-in provision, why not extend the shut-in provision, but keep my royalty at 15%? Keep my royalty at no deductions. Keep my royalty where you probably can't do affiliated sales and use index pricing. Ask those questions and see the types of responses that you get. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. And that's why I say there's such value in reviews, consultations, meeting with someone who knows what they're doing, who's working for you, not the company, to offer you the insight and the guidance as to what may be occurring. And what we know, what we speculate, and identify. Hey, look, here's what we think. We can't say this with 100% certainty maybe in certain situations, but this is what we think, and this is how we evaluate it. And you need to weigh, unlike that, mentally, envision these scales of justice. You have scales, and you need to weigh all of this information, and whichever weighs the heaviest is going to be the decision that you make. So if you have more items that are weighing towards doing a lease now or more towards waiting, well, that's ultimately then how your decision is going to be made. But boy, if you don't know how to weigh these things, what should you be giving more emphasis to? What should you be giving more weight to? What is the potential ramification of index sales? What is the potential ramification of deductions? Hey, can there be a deduction cap? More companies are doing caps on deductions, saying that, we can take deductions, but they can't exceed a certain amount. You need to explore all of those things and find out what's available to you by somebody working for you, not by somebody working for the company. And by the way, the landman doesn't work for you. So you need to get that information to make the right decision. And remind everybody, too, if you missed any of the earlier show, because it was a good show today, I think I did it, so I think it is, go check out pagasleaseattorney.com, pipelineattorney.com. Today's show will be up on Monday morning. Check it out. Go back, listen to the show, listen to many others. We want to make sure that we're getting you this information, that you have access to this information. And as we head to the close out of this show today, I want to go back and remind everyone again, if you're in that Susquehanna County area and you're leased to Cabot and you receive this multi-unit well consent documentation, I highly recommend that you get individual advice from an attorney working for you who knows what they're doing, who understands the development, who understands the process, who understands the lease modification aspect of this agreement, who understands the uncertainty of future development, who understands what information you need to know and how you can protect yourself. Really, really strongly encourage everybody to go seek counsel. Now, I recognize that I'm a lawyer who does oil and gas work, and that certainly can be a self-serving statement. However, nonetheless, it is very true. And I've done a lot of these reviews, consultations, very familiar with these issues. We always have to make sure that we can assist you, that there's no conflict in representation, but really would like to hear from you to see if we can help you. 570-307-0702. These are important documents. There are things that you need to know that I don't believe the company is going to tell you, and I think you need to know these things. So you can give us a call, 570-307-0702, or call somebody, but let's stop simply signing bad agreements. And let's also never forget, the landman works for the company, not you, the land owner. This is Attorney Doug Clark, All Things Marcellus. Join me each week right here, Sunday, 8 to 9 a.m. Call us 570-307-0702. And most importantly, have a great week, everyone.